Hello, everyone, and welcome to another episode of our civil litigation mock trial course by the Dieko Daniels School of Law. And on today's episode, we will be talking about drafts, right? Draft for the magistrate courts. When it comes to law school, what are the drafts that you are supposed to pay key attention to when we are speaking about the magistrate court? The first, which is going to be the claims and particulars of claim. Do not forget that if you are going to the magistrate court, there are two ways to which you activate the jurisdiction of the magistrate court. You either go by a claim or you go by an originating application. And I've told you several times during the course of the class that law school will seldomly ask you to draft an originating application, but are very likely to ask you to draft a claim. I also told you that when we are talking about claims, claim is divided into two. We have the ordinary summons and the summary summons. The difference between the ordinary summons and the summary summons is an application to the registrar of the magistrate court that the case should be set aside for summary summons. Do you understand that? That a summary summons should be issued for that particular case. If you do not understand what I'm talking about, it means that you have not listened to my lecture on magistrate court. I had a lot of classes where I broke down the nitty-gritty of magistrate court for the purpose of law school bar finals, and I've already explained all this. Now, what is important for us to then look at, which is going to be what we'll be looking at, in this class and in the next class, it will form the substance of our class and the next class, is how to draft a claim, right? As ordinary or summary summons, they are the same thing, but how to draft the claim and particulars of claim. Do not forget that when I was teaching the class, I told you that it's still the same thing. It's the same way you draft it, but the only difference is one is for liquidated money demand. The other is when it is contentious. So the other in this context here is the ordinary summons. When we are talking about ordinary summons, it is contentious. When we are talking about summary summons, it is non-contentious. It is for liquidated money demand, right? So let us look at the nitty-gritty of what it is to draft a claim and a particulars of claim. In our next drafting class, we'll be talking about the nitty-gritty of drafting the letter that you are supposed to send to the registry as a form of application to issue a summary summons for a case. Do you understand that? So just to do a recap again, you have a problem, a matter. We are going to look at one problem right now, and your client has come to brief you. Oh, this is what happened. You know the monetary jurisdiction of the magistrate court is below 10 million naira, right? So you know that this matter is supposed to go to where? The magistrate court. You know that there are two ways to institute a matter in the magistrate court: claim and originating application. You know that this one is a contentious matter, so let us go by claim and ordinary summons. So if I'm going to issue an ordinary summons, what are the things that I'm supposed to file? Three things. Number one, your claim. Number two, your particulars of claim. And then number three, which is not filing, but a necessary condition, you must then pay filing fees. So the question is, as a lawyer, how do you draft that claim and particulars of claim for the purpose of practice, but most importantly, for the purpose of bar finals? How do you draft your claim and particulars of claim? That is what we'll be talking about in this class. I'm very sure that you can see your screen right now and you can see what is written on it. The first line when you are drafting says in the Magistrate Court of Lagos State. Funny thing is, students make mistake when they are writing magistrate court. The S comes first before the apostrophe, not the apostrophe coming first before the S. Why? It's English, it's grammar. We are talking about the plural, magistrates. It is both plural and possessive at the same time. When you are having more than one magistrate, it's supposed to be the normal magistrates with the S, no apostrophe. But yet, you are telling us that it is the magistrates courts. So therefore, there's supposed to be a possessive S. So when it is plural and it is possessive at the same time, it's then going to be magistrates with the S and then the inverted comma coming after the S. Do you understand that? So in the magistrates courts of Lagos State, most people make that mistake. Please do not make that mistake in your exam. And for the purpose of our course as well, please do not make that mistake. Now, in the Lagos Magisterial District, now when you are in practice, there could be Ikeja Magisterial District, Epe Magisterial District, all this Magisterial District is none of your business for the purpose of law school and the purpose of our course. Do you understand that? That's the civil litigation mock trial course. It is none of your business. What you should look at is in the Lagos Magisterial District. Holding at Lagos. Have this in your head. This is going to give you at least half mark for your exam. Number two, you look at this part that says suit number. Now, some drafts will tell you claim number. But if you look at law school standard, which is another thing that I would ask you to ask your lecturers, what do you use? When I asked mine, he said you use suit number, not claim number. Do you understand that? That is why I use suit number in my notes. Also, between Mr. Tony Alabi as the claimant and Mrs. Oyinlola Okeke as the defendant. Now, note that the designation is claimant and defendant. The designation is not applicant and respondent. The designation is not petitioner and respondent. The designation is not plaintiff and defendant. The designation is not, funnily enough, it is not prosecution and defendant. The designation is claimant and defendant. Please take note of that. So immediately you are done with that, then we now go to what is known as the claim. You go to the claim first, you let the court know this is the issue. Then you now go to what is known as the particulars of claim. The particulars of claim is now you explaining the issue. Do you understand that? Now, in your claim, I will teach you key ingredients that ought to be in the claim. Number one, what is the claimant claiming for? You need to state that the claimant is claiming for the sum of 600,000 naira only. From who is the claimant claiming from? Are you seeing that? This person is claiming for A. From who? From B. Do you understand that? The claimant is claiming for 600,000 from the defendant. That's the first key thing. Three things that we have talked about now. Who is claiming? What is he claiming? From who is he claiming? And why is he claiming? Being the balance for the supply of 2 trailer loads of tomatoes for which the defendant has failed to pay despite a letter of demand dated. It is very important that you add that. If you don't add that, you are failing. Why did I say you should add that? Because before you commence an action, just like an action of this nature, it is important for you to have sent a letter of demand. In practice, if you are asking for money or you are asking for something from someone, you should have sent a letter of demand. It is a prerequisite. Before you can institute an action, they will ask you, where is your letter of demand to which the other party has failed to honor? So it is important for you to have a what? A letter of demand. Therefore, in your claim, you are supposed to have how many things? You are supposed to have the claimant, right? What is the claimant doing? The claimant is claiming for how much? Is claiming for 600. Okay, 600. Owed by who? Owed by the defendant. Three things. Who is claiming? What is he claiming? Who is he claiming from? Why is he claiming? Go like that. Who is claiming? What is he claiming? Who is he claiming from? Why is he claiming? And then your letter of demand. If you put it like that in your head, you would know how to draft a claim in exam. Who is claiming? The claimant is claiming. For what? For so amount. From who? From the defendant. Why? Being the cost of so and so, and then you then add your letter of demand, which the defendant has failed to pay despite a letter of demand dated so and so from the claimant served on the defendant. Do you see that? Can you see how easy that is? Good. We then go to the particulars of claim. Now, when we are talking about these particulars of claim, when you are in the magistrate court, it is slightly different from what you would find when you are in the high court. Now, but there are two things that must be very important. When you are drafting particulars of claim, they are known as matters of inducement. Number one, must introduce the claimant. Number two, must introduce the defendant. If there are more than one claimant, number one will introduce the first claimant. Number two will introduce the second claimant. If there are more than one defendant, number three will introduce the first defendant. Number four will introduce the second defendant, and so on. But you are supposed to introduce all the claimants and all the defendants in a suit. Then you will now start drafting. Now, when you are drafting, you will pick a question, right? When you are drafting and you are looking at your question, look at it. You are drafting in a tailored manner. When I say tailored, I am saying that you start from the very first day. What happened on the very first day? On the 12th of, I believe this August 2019, as is customary, the defendant requested from the claimant via a telephone call to supply 2 trailer loads of tomato. You can see, this is the first thing. This is how it started. I was on my own. The defendant called me and said that I should transfer him 2 trailer loads of tomato. Okay, that's your first paragraph, right? Now, the second paragraph, the agreement of the parties was that the cost of tomato in each truck bearing 250 baskets of tomato was how much? Was 800,000 only. Another thing about drafting is that when you talk about an amount, you will write it in letter, then you open the bracket and you must write it in words. Those are one of the subtle keys of drafting. So the same way I said 800,000 now, you see that I opened the bracket and I said 800,000 naira only, right? Then you continue. Hence, the total agreed cost of the tomato was how much? Was 1.6 million naira only, because there are 2 baskets. So you can see, we started from, there was a call by the defendant that said that we should give him tomato. Then this was the amount of tomato that he ordered. Now, a further agreement of the party was that there was a deposit of what? 1 million naira only, which will be paid to the claimant guarantee trust back immediately, and the balance will be paid upon delivery of goods. You see that for the agreement, what does it state? That there is going to be a what? A deposit. Do you see? I want you to just be like a judge. Look at how we are flowing sequentially, right, in terms of the particulars of claim. Now, one thing that you would note here is that if you have read further and you know how to draft a statement of claim, naturally, what you ought to be seeing is the claimant avers. The claimant avers. So, the claimant avers that there was a particular agreement that states that so and so. The claimant avers. Now, when you are in the magistrate court, it is not so strict in terms of drafting, although there are some rules that you ought to obey. But in terms of the body of your message, which is where this paragraph 3 started from, after the matters of inducement, it is not necessary, right, that you begin to write the claimant avers. Just make sure that you go sequentially, you write out. So we talk about an agreement, we talk about the details of the agreement, we now talked about a further agreement as to deposit. We now talk about, yes, the deposit was paid. Now look at number 6. The sum of 1 million naira only was immediately paid by the defendant to the claimant's account as agreed by the parties. Now 2 days later, the claimant then delivers the goods. Now we're in paragraph 7. The claimant delivers the goods in full, but all entreaties and a letter of demand dated so and so day to pay the outstanding balance has not been honored by the defendant. The failure to pay the balance has limited the claimant's ability to pay the suppliers of the tomatoes. Hence, they have refused to make further supply to the claimant. So you can see what we are saying. I want you to look at how we started sequentially. From after the matters of inducement, from the paragraph 3, we talked about the first event, then we flow to the second event, then we flow to the third event. It's not as if we started from the letter of demand first. We now went to, after the letter of demand, okay, now let me now tell you what now happened. This is not super story. You are not doing flashback here. There's no flashback. You go in a sequential order from the beginning of the event, and then you keep working up to the point where you serve letter of demand as a result of the person not paying up and all that, right? So now, after you have gotten to the point of letter of demand and your story has ended, you will now claim. Now, I wrote number 9. The claimant claims as follows from the defendant. Another drafting style, which you can also adopt, is to say, whereof the claimant claims as follows. But I prefer this style. Both of them is applicable for law school. You can say the claimant claims as follows from the defendant. You can say whereof the claimant claims as follows. Any of them would work. Now, A, what are the things we are claiming? The payment of the sum of 600,000. That's number 1. Being the outstanding contract sum payable to the claimant. Now, B, the sum of 100,000 naira as general damages for breach of contract. C, the cost of this action. So you can see, after we've gone sequentially, we now tell the court, this is what we want. We want A, B, C. And how do you tell the court this is what we want? In that paragraph, you say whereof the claimant claims as follows. Or you say the claimant claims as follows from the defendant. Right? And immediately after what you are claiming for, you then go under, right? Dated this dash date. Make sure that this is in your draft. All these things that I'm saying is half mark here, quarter mark here, half mark here, quarter mark here, half mark here, quarter mark here. Little by little, you get your A. Then you will see that there is a position where you are supposed to sign, right? You see how, I left the space for signature. Make sure that in the exam you sign. It's important that you sign. Then you write the name of the person, and then, now note that when you are writing the name, there are key ingredients. This is about 1 mark. This part is about 1 mark. Now, what do I mean when I'm talking? Now, after you have written, the name of the lawyer comes first. Please listen. The name of the lawyer comes first. Then his chamber comes next. Then after that, you say he's the claimant's counsel. Then you now put his address. Then you now put his email, and you put his phone number. If you miss one thing in what I've just said, you have failed the mark for that particular thing. Which means if it's 1 mark that is allocated there, you have failed it. The name of the lawyer comes first. The chamber of the lawyer comes next. Number 3 is that he is the claimant's counsel. Number 4 is his address. Number 5 is his phone number or the email. And then number 6 is the email or phone number. That one can be juxtaposed. But please go in this order. And then you also put for service on. Now, another key thing that you need to notice is that when it comes to originating processes, please listen. When it comes to what? When it comes to originating processes, you serve on the defendant himself. You don't serve on the defendant's lawyer because you don't know who the defendant's lawyer is yet. You serve on the defendant himself. Then the defendant will now go and look for a lawyer that will now respond to your application. That's your originating process. So you can see, for service on who? On the defendant. Then I put his address. His address, then, we continue. Please, it is important for you to take. There are so many subtle details in what I have taught so far that you might overlook and say this thing. Please, when you are serving an originating process, you serve it on the defendant. Then you put his address, his phone number, and email. When you are, writing your own part, which is usually on the right part, right? You must put your signature, is important. Then after that, you put your chamber, then claimant counsel, then your address, then your phone number, then your email. Anyone misses, you are in trouble. The dated this dash day, very important. Your claim Very important. When I talk about the claim, I'm talking about your last paragraph where you say whereof the claimant claim as follows. Very important. The sequential order of which you put your events in your particulars of claim. Very important. Your matters of inducement, where you introduce both the claimant and the defendant. Very important. Your claim having key ingredients. Key ingredients in this case being who is claiming, what is he claiming for, who is he claiming from, why is he claiming, and then letter of demand. Did you see that? Who is claiming? What is he claiming for? Who is he claiming from? Why is he claiming? And letter of demand. If you can do this, you have perfectly known how to draft the claim and particulars of claim for the magistrate court. Now, to round up, I want you to just take a look at what it is like to draft for a company. So you can see this is the same structure, but in this case, we have Dramendra Coal Limited as the claimant and Five Face Nigeria Limited as defendant. Now, if you look at it again, you see the claimant claims for how much, from who, being the outstanding balance of what, and then the what, the letter of demand, which must have been served, and the date it must have been served. Please, it's important to don't just say letter of demand, say the date that your letter of demand was served. And you look at the particulars of claim. Now, I just want to show you the matters of inducement here again so that you would understand. Look at the matters of inducement. The claimant is a limited liability company with its registered address at so and so. The defendant is a limited liability company with its registered address at so and so. You can then put adjasa, right? When you say the defendant is a limited liability company with its address so and so within the jurisdiction of this court, you can decide to add it, right? All those more formalities, more key formalities would be done most times in the statement of claim. Do you understand what I mean? But this one is still proper for, for the particulars of claim. If you write, after you write the address, you now say within the jurisdiction of this court, it still suffices. You still are drafting well. But I want you to look at the matters of inducement for a company. You can see the way it is drafted, right? Look at the matters of inducement for a private person. Note that in my matters of inducement for particulars of claim, I did not basically say where they live, because don't forget that when you are activating the jurisdiction of the court, it is not just that you can say where he lives, but you must say that the defendant is living or carrying on business in that state. Do you see what I'm talking about? He's either living or carrying on business in that state. So in this case, if you look at our particulars of claim for that of the persons, the ones we talked earlier, not the ones of the company, you will see that the defendant is a trader who engages in buying and selling of tomato at the Maitu market, Lagos, within the magisterial jurisdiction of this court. So it's just how you intend to draft it. Magisterial jurisdiction of this court, within the jurisdiction of this court, everything suffices. But when we are drafting statement of claim, right, then we will go deeper into certain other things. And, if time permits, I would also like to juxtapose between the statement of claim, in high court and the particulars of claim in magistrate court, if time permits. But I think with this, we've done a good job in learning how to properly draft, particulars of claim and the claim itself, to which we can activate the jurisdiction of the court. The next thing and the last thing that we will be drafting for magistrate court will then be the letter that you send to the registrar of the court, that summary summons should be issued for a matter, right? If you want summary summons to be issued for a matter, you must specifically write an application in form of a letter to the registrar of the court that the summary summons should be issued for the matter. So yeah, I believe that you guys enjoyed this class so far. I enjoyed it myself, the drafting class. I guess we are going to meet again in our next class where we talk about drafting application for summary summons. I will see you in our next class. Have a very beautiful day.